that we are having a mission, National Intellectual Property Awareness Mission, which we started from August 2021. So we are now moving on to that mission up to 2022 August. We have a 1 million to be covered. So I am in charge for the Karnataka whole state under that program. So here I am just officially, we have to have a disclaimer. So of this PPT, this is the disclaimer. We generally share, no issue with the sharing the PPT, but as far as our Office of CGPDTM, Controller General Patents and Designs Trademark, this is what, so without any permission from them, they should not use these slides. So why we are here? So here, so what Einstein said about that intellectual growth should commence at birth and cease only at death. So India or a person everywhere in the world, so whenever from the birth to that, he will be active and he will be, even if you see children, they will be more creative than us. So some things they will do all these things and they will try in all the possibilities, whatever it can work for their play, whatever their things. So we will be creating the things at all the times, whether it is for daily life or in our life. So human is born with that capacity of intellectual creations. So these creations, which only should be taken advantage with those creations, that's why we are here. How I am going to talk in next 1 hour or 1.5 hours. So on this, how we can be, as I said, we have moved in 2021, so 46. This is the Global Innovation Index, so which is WIPO will release every year. So this is the position. So the top one is the Switzerland, and so we are aiming to come in top 10. That is what our aim to be moving. In 2015 we were at 81, and 10 years back we were at 84. So today we are at 46. So as even Registrar sir was also, and Dean sir was also pointing that, so for this we have to give awareness and encourage our youth to achieve that. So what is intellectual property? So in Hindi Bauddhika Sampattu. So what is this? So intellectual property. So human mind we generally call as intellect. So whatever it is created by the human mind, not naturally existing. So there can be something which is naturally also in the evolutionary process, new things will be coming, but those are not the creations of by us. It is the creation of nature. So apart from those natural creations, we through our mind, generally by research, so we create many aspects that can be made as our own property. Whatever I create, those can be made as our property. And if I get that on that a property right, so that will become intellectual property right. So that is right is a legal terminology. So right, like we have fundamental rights given by our constitution. So like that it is of a statute created right. So intellectual property. So if you know, we all know about the property. So sampattu, asti, you can say any name. So we all know, even human is fond of acquiring in lifetime whatever the property, car, bungalow, all these things we can have. So that property is having, you can divide it into two classes, that is movable property property and immovable property. Like this REVA University's building, it is an immovable property, and in that you can also classify that as tangible property, intangible property. So we can touch and experience and we can see, like this building. So REVA University property we can see, we can touch and experience. That is the tangible nature. Tangible, immovable, and like car, bus, train, whatever you own, so it will be a movable, tangible property. But all these intellectual properties, they are all intangible properties. If I say that I have, like sir was saying, and in the report I have seen that there are 345 patent applications in a calendar year filed by the REVA University. These are all properties, but we cannot show what is that property. So that is the intellectual property. So whether you can, so if you are getting registered with the government, like every country has their own laws for this IPR, intellectual property registrations are granted. So that is all becomes intellectual property right in those countries. So these are territorial in nature. If I take a patent in India, it's only applicable within the territory of India, not applicable in US or Australia, where I cannot enforce that. If I want, I have to take my right there as per their law. So these are territorial rights. All the intellectual property rights I am speaking. And these are all negative rights. The main characteristics, if you compare with the other tangible properties, intangible properties like intellectual property rights, they are all negative rights. So if I want to take a patent or trademark or copyright, what is the advantage that I can restrict my competitors. Others I can restrict use for the competition in the marketplace. That is why these are all negative rights. Positive rights means if I purchase a car and I have to register mandatorily with the RTO. Without that I cannot run the car on the road. Is it or not? So that gives me a positive right. But here if I have created something, anything, any technology, I have created it. So if I don't want to restrict others, I will also use, let the others should also use, then you don't require any registration. But you want to restrict other competitors, then you require these negative rights. Right against the public. That is what I can say, it is a completely a negative right. If you are having a charity work or you want to society improvement work, you can really give those all technologies developed. Open research or so many things are there. So, but this is not, this is against. To kill the competition or to make a anti-competitive, all these things in the world, we have this system, intellectual property rights. So among them prominent are, today's topic I will give on all these 6 aspects. First comes is the patents. So these are industrial designs, trademarks, geographical indications, copyrights, semiconductor integrated circuits, layout design, SICRD. So these are the 6 intellectual property rights. Don't think that these are the only 6. There are even trade secrets are there, plant varieties rights are there, several of the other also. Even India we are trying, because last month I attended one of the intergovernmental committee meeting at Geneva. So there also we had proposed a traditional knowledge. India is having a rich knowledge of what you can say Ayurveda, Unani and Siddha systems of medicine. So this can be a separate intellectual property rights. Whoever is the, whether committee holds or family holds from generation after generation, we are trying to get the recognition throughout the world as a separate intellectual property right. But so far it is Even 42 meetings has over, but still we are not successful to convince the globe about the traditional knowledge of India or any country's traditional knowledge and its importance as a intellectual property creations. So here one by one we can go to that. Here if I want to show all the different intellectual property rights in a single product. So we have all seen that this laptop are Apple's. So here there is a LED display which is a technology. LED so it can be anything which can be a technology which is the patent you can take for the display technology. So body of a design of laptop, so it can be a industrial design, and the sign which is cut Apple, so which is everyone knows that it is a trademark of the Apple. And then you have a user manual for this laptop that can be done by this company for users of this laptop, so it is can be a copyrightable, and there is a chip which is inserted inside to make this computer, the laptop work, so it can be a semiconductor integrated circuit layout designs. So all the IPRs except GI, I will come to that GI. So with it is GI is an entirely different aspect. So here you can have in one the 5 intellectual property rights. So you can. Now we go. So what is required is that to create this, you brain. So brain, you cannot stop the brain. Even if you are sleeping also, you are sitting here in the room. So you cannot stop that. It will be thinking. Lot of processing going on in the brain. So ideas may come into mind and it can escape in the temporary folder and like that. So brain, it can have so many ideas, but the ideas cannot be protectable. Any of the IPR you will not get through the idea, but idea you have to use with the human resource, either alone or with the laborious work of you have to express that to make it into a property. And by sitting here I get that I have one idea very good, so I can develop this type of technology, that type of technology I can, but it's of, you cannot say it is a property for you. So unless you express practically, whether it is anything, any intellectual you are getting in your mind, so but you have to express. So with your resources are available, with your labor work, you can create that property. So that property you can protect as a intellectual property right, and that will exclude other. So I already said it is to exclude others and get benefited through utilization of commercialization, as sir was speaking on that. So commercialization, definitely. So every intellectual property is having 3 stages. That is fostering ideas to IPR, like that, fostering your ideas to work with them to create something which is new in the world. So then it can be protectable, that is protection. Then third stage is the marketing or commercialization of that technology, whether you do or you can give it to others. It is for the companies. So there you can earn the profits, whether it is as a royalty when you are giving to the company, or you can yourself make a startup company and to get the benefits of that your creation. So here is the how to earn through these intellectual property rights. Either you can own use, so you can develop your own company through that creations, lot of creations, and you can use it for earning, or so like academic researchers may not be interested for commercialization directly, so they can license or assign to any companies whoever acquires them and or create a franchise, and so there can be you can work out according to suitable to you. So or even university is having lot of filings from the REVA University. They can through the IPR cell, it is very active. So they can have their own the Institute for Commercialization, because last November I was in Denmark. So where I have seen a beautiful ecosystem for this fostering, then you have protection, and third it is the commercialization. So 1 month program I attended on these 3 aspects. It was beautiful there. They have institutional support. Even we are trying from our government of India for our academic researchers, definitely there should be a support from our ministry as a separate institute. They can acquire the technologies and they can commercialize. Even though NRDC is doing that, but not in large scale, but that can be in future, definitely it will be one of the aspects you can see in India. So I have myself submitted one of the project to that government of India. What there in Denmark they are doing is all the technologies from individuals or academic researchers, they are taking that and they are prototype development they are helping. So in all the facilities they can use, it's a government institute. So they can, and the companies will be invited there to see that prototype. If that is the prototype developed, any company can acquire that technology because everything is in front of them. So this is the facilities I have seen. It was wonderful and it is definitely working for them to commercialize. That's why it is Denmark is in top 10 global innovation index. So a very small country but still rich with the knowledge economy. So common persons also can have a benefit of this. So generally for the pride and academic in biodata. So all intellectual property rights, I have a properties, I can put in my biodata, I have this many patents, trademarks, all these things we can say that. So and also it is a pride. But for a businessman, where I am interested is that so commercialization of the technologies and brand building and earning through that and investing that earnings to create more and more competitive technologies so that it will run the show. All the technologies you are generating and through that you are and invest some profit, at least 20% of the profit into the further future technologies so that it will run. So first we will move on to the technology, that is patents. So what is patent? It has a very small difference with the patient. If I put one eye, it will become patient. Many times we used to, so around 10 years back we used to receive letters like that. Many times that used to be mistake with that spelling, that is patient office like that. So they used to write. Nowadays we are not accepting anything in postal, very less. So all through electronics or e-filings we are getting, we are not seeing, but it used to be, it is becomes, and they used to say that we have did 4 years research and 5 years research and we are not able to get quickly the patent, so we are becoming patients. So that used to be the earlier, but right now we are having almost 800 officer staff in all India patent officers. So we are ahead the curve. So we can say that very quickly we are doing this patenting work. So it's a right, I told right is a legal term. So right against others. Hakku, right. So it's a sovereign right or exclusive right given to a applicant. Whoever applies, he will get. It's not that whoever invents, he will get. In REVA University, if you are doing wonderful work and you are not protecting, we are not coming to REVA University and giving you that right. You have to come to the patent office. And it is the applicant, whoever applies, he will become an applicant, and for him we are giving an exclusive right for excluding others or stopping others from making, using, exercising, vending or importing, includes the importing also. If anything product is patented, anyone cannot import into India if that is there. So here, for all these are all commercial activities. So many times, Balasare, I will get that. Whether the patented technology I can use in my home, you are free to use any technology which is available in the websites of patent office freely for your home purpose. No question of infringement will come, but it is only for commercial activities. It will be, you cannot use as a competitor for the patent owner. That is what it is. It's not that if anything is there, so if anything is, information is available, you can use freely for doing your own activities and for even research also. In India, it is free. For any patented technology, you can use it for researching. But in US, there is a restriction for the research methodologies. You cannot get a free use. But in India, Section 100 of Patents Act 1970 will give a right that anyone can use freely. Commercial, academicians, anyone. So in return to that, what you have to do? In return to that, disclose it in a specification such that average knowledge person will understand and will make that product or process to reproduce the invention. So in crux, I can say that what is patent? It's a exclusive right given by a government, any country. Wherever you apply, that government will give you that right against for a limited period. So that's also important, for a limited period. It's not for a number of period. It's a limited period. So anyone files a patent application today, that is 28th April 2022. So his expiry date is fixed on the date of filing itself. So 20 years from today. So 28th April 2042 is the last date you want to earn through the patent. So that is 20 years from the date of filing. So whenever you file, its expiry date is fixed on that. For a limited period, to exclude the competitors, without license, if anyone does uses your technology, you can catch it at the marketplace, but through the judicial process. It's only that is civil rights. No criminal prosecution, you can take it. So you say civil right, you have to file a suit against infringer, whether product or patent which you got an enforceable right, and you can catch them. So that's what in return, complete disclosure. So here is the major thing which I just wanted to say. So many Indian applicants are failing. So they want to keep something secret. Many times they will come to us and say that, no, if I disclose everything, what I get it? Actually, it is the other way around. You have to disclose in such a way, everything, instant information is available through your patent application. Then everyone is tempted to copy your technology. If they are copying, you can catch them. That is actually the most beneficial aspect. If you are keeping secret and coming to patent office will not grant a patent with the off knowledge. You have to disclose completely. So our motto, our government's motto is not in this giving the reward to you. Its main motto is you have to disclose completely to the public so that public will be benefited. We used to say that India, in ancient India, has a rich knowledge of the like Ayurveda, all these things. But Today we have not recorded those all. We might have lost it. But this is the patent system will offers a great advantage for our next generations. Whatever you are giving us technologies, we will be recording at one place and it will never be lost. So anytime 24/7 you can access. Same thing other global patent offices also will do, so that there will not be any information loss for the future generation. So that's why we are encouraging with the 20 years reward to the inventors. In 20 years, it has been decided that in 20 years is a long period to encash one of the technologies. Especially in our electronics, it will be hardly 5 years one technology can, it will be exhausted, other technology may replace. So it's giving that 20 years is a long term to encash all the technologies. So that's why we are having 20 years. So using invention means without license, if anyone uses, you can catch them. So it is the qualified right, but it has also a fundamental duties along with that. So these are some of the patents which are granted. First patent, it is an efficient Panka pulling machine. This was, and these are all great scientists who had a patents on these, like Thomas Alva Edison phonograph, and Graham Bell on telephone, Wright brothers aeroplane, so Pasteur is having rabies vaccine, and then Fleming is development of a antibiotic. So there are several things you can also get it through the Google. So recently we have got this information through Google. So even Tata has applied, though it was not that much successful, but it was applied 34 patent applications in one product development, that is nano car. So a cheaper version, that's what their aim. So it was, and hepatitis vaccine, this is sold for this amount for a healthcare against the hepatitis disease, and it is the Jaipur food, it is at US $28. There are simple inventions also, like this is the one, you can see so many inventions you can get it. These are all taken from the Google. So this is the drones. In future maybe a technology completely driving the economies. Some I just wanted to show one or two for you, your curiosity, like this ring pull can. Everyone might have seen this type of things opening. This is a very simple. And one inventor invented, Coca-Cola company was behind him to get the technology. They were offering huge sum of money to them, but he did not. He realized that. So it is having a one, but it is only a one ring and on a can. Nothing else is there. So if someone says in India, it is, oh, nothing is there, what is this great? You have not done any noble work. It's not that. All the work should not be a noble work. So even you have to assume that market potential, which technology will take into turn, we don't know in the market, which technology will be accepted. So here, this person has earned approximately for 20 years, on an average, 1.2 crores in Indian rupees per day. This is the one ring pull can. If he was not patenting this, anyone could have been freely used this technology. So that's the, I'm not saying that all the technologies will be having this much of potential. I'm just saying that it is a simple technologies can also, like, see, this is the paper clip patents. If someone says that I have a patent on paper clip, we may laugh at him. So we will be seeing so many type of small changes which are beneficial to society and for commercialization. But we never think of protecting and earning through that. So the four inventors who invented this twin brush technology, so you can just put it on your teeth, it will brush it. It's available. So it is for 3,000 crore one technology. So this is the as whatever we are inventing, we can try with the system, but for that we need to have a knowledge about that system. So now I just want to say what you need to do for filing a patent application. Now, there are 4 mandatory forms. Form number 1, which is the details, like students who has enrolled to this REVA University, they might have filled one online or offline form. Same time you can online, you will get it, or offline you can take a printout and fill it, or you can take in the Word and fill it. So here all the who is the applicant, who is the inventor, maybe n number of applicants, n number of inventors can combine for one invention and they can file it. And the second is the specification, where you need to details of your invention you have to disclose to the patent office. That is based on this only we are granting patents. Complete details, no secrecy in keeping that. That's what our duty. So since 18 years I am in patent office, we are looking those applications only, whether they are meriting for the grant or not. So this is our examiners, they will be making a technical report, whether it can be granted or not, we controllers. So whether to grant or not, we will decide finally. So all the technologies, whatever it is to be developed with the title, prior art search or literature search, you have drawings, description of the drawings and examples of the working examples of invention. And the third one is the any details of you have filed already in foreign. If it is there, otherwise nil you can declare. And there is a declaration as to inventorship. And the form 18, that is the form you require to file a examination request. This can be filed on the day of filing, or it can be taken up to 48 months. You have a time for 4 years. So you have time so that you can take it and file it. So day 1, on the basis of this form number 80 only, we need to examine. So these are the 4 important forms. Form 1, Form 2, technical specification, and Form 3 and Form number 18. So what are the fees for that? You need to pay the fee for that. Though, so I can just, might be, Director Madam might be knowing, in the KAPILA scheme, whatever the academic researchers are filing a patent application, this is reimbursable. Patent office fees, whatever you are paying, so it is all reimbursable under the KAPILA scheme. You are filed in patent office and you can get a through the KAPILA scheme, that is AICTE scheme. MIC has developed that. So form number 1, for all the educational institutes or researchers, it is 1600. And form number 2, there is no fee up to 30 pages and 10 claims. If it is beyond that, you need to pay extra fee. And form number 3, there is no fee. Form number 5, there is no fee. And form number 18, that is to be 4000. See, there is a difference. 1600, you just want to get a publication in Patent Office Journal, you can just pay 1600 and leave it. But if you want to enforceable right, then you need to pay the 4000. So then we will send a examination report, and then you need to reply within 6 months. All these things will happen there. So that is what the fees for that. So this 5600 is a fee which is for the online filing. For offline, 10% additional, because we have to again digitize the records. So whenever you are filing by post or by coming to the patent office, you need to pay 10% additional through the demand draft or by paying at the counter in patent office. So for companies, large companies, this is the 8000 plus 20,000, 28,000. So this 5600 if you pay as an educational institute or academic researcher, it will be reimbursable through the KAPILA scheme. So who can file? So any researcher, any inventor who is there, so they can file, because they are the true and first inventors. or they can assign it. Any researchers or students at REVA University, they can assign it to REVA University. So REVA University will become assignee. So or any company they can assign with them. They can also sell the patent rights. All these things will happen. So that is the assignment, or any legal representative of a deceased person. So this is the third category, where, for example, if some researcher is doing in the laboratory great work or any novel creation, but before reaching to patent office he died, he could not apply. So the rights for that research, inventor will be the deceased person, but rights will go to the person that is the legal heir, that is legal representative of him who they can file. We accept that. So how to file a patent application? So I have now drafted Form 1, Form 2 and Form 3 and Form 18. How to file? So there are two, e-filing and then that is offline filings. Earlier, before 2012, if I say, it was the only option. So now we have e-filing. E-filing also there is a tool, that is with a digital signature certificate, you can file a patent. So that is class 3. You can take from either e-mudra or encode solutions. There are some, or TCS, they are giving this digital signature, DSC, digital signature certificates. You can take it, or through OTP based, like Aadhaar card, you can link with the mobile number. Through OTP also you can do the e-signature. This is a bit, DSC is a bit costly affair, and if you have an e-signature, so you have to register in our office website, and there you can upload your documents directly and sign the documents, because signing is the mandatory. So, and the other offline conventional method, you can come over to patent office and file the Indian Patent Office, or by post you can through the demand draft. You have a option. So we have 4 patent offices. Unlike US and other countries, we have 4 patent offices located at 4 metros: Chennai, Mumbai, New Delhi and Kolkata. So all this southern jurisdiction comes under the Chennai patent office, and western in the Mumbai, and northern in Delhi, and the eastern other rest of the part is covered by the Kolkata. So if you are doing through the address of the REVA University at Bangalore, so you have to file office Chennai. So online filing, if you fill the pin code, it will automatically take the jurisdiction. You need not worry about selecting. But if you are filing at the office, you have to come to Chennai office, or you have to post it to Chennai patent office address. So hard copy at the appropriate office. So you have this website also, e-patent filing, that is there. So you can class 2 or class 3, but prominently it is the class 3 signatures they will file. So you have to log in, e-filing portal, ipindia.nic.in website. Here you have to make a sign up, first register with that, and then you can use the facilities either through DSC or through the e-signature. So there is we recently started with that fast tracking of, because we were having a complaints on patent office that, so lot of time we are taking it for the examination and granting of patent application. Since 2016 we started with the expedited. So now either startup companies, because we are, Government of India is encouraging to have many startup companies. So that's why we are also encouraging granting of a patent quickly to the startup, or MSME or SME, that is small entities. And all the natural persons, if all are natural persons and among them at least one of the applicant is woman applicant, then they are eligible to file a fast track application, that is expedited application. And either government, any government, state or central government departments, they can file the fast track. And if they have filed international application, this PCT means PCT international application, Patent Cooperation Treaty. So in that, if ISA is India, then they can, so, or there is a agreements between some countries, like we have an agreement between JPO. So there also they can make the fast track applications. So these are the categories they can file the fast track applications. Of course, this is a fast track we have introduced almost 6 years back. But right now we are, except few subjects, all are on fast track mode only, because almost pending has been cleared in the patent office. We are even 2021-22 applications we are examining in several branches. So if it is now, it can be quickly taken up. So processing. So there are 3 types of applications. What I explained is for the ordinary application. If you have conventional priority, that will be a conventional application, and international application you are filing PCT application. So here, if you are filing ordinary, there is an option provisional or complete. So if you are at the start of the research, you can file a provisional application. Within 1 year, you can complete the invention and file the complete specification. And it will be, first and foremost, we will publish under after expiry of 18 months, or if there is a form number 9, we publish early. So after that it will be examined with the examination report if there is a form 18 filed. So compliance, if that is within 6 months or extendable by 3 months, and if there is a merit, it will be granted quickly, otherwise it can go for the hearing, and after that it is the grant or rejection will happen. This is the process. So how the patent application moves in that, whenever we receive an application, that is by the applicant, it will be screened first subject. If there is any invention which is related to atomic energy, we will not generally publish, because it's a very dangerous technology. Sometimes atomic, like radium, thorium, uranium, all these things, materials you are using in the technology, if that type of technology, we are not going for publication, and we are referring it to atomic energy department, and they will give, if okay, no issue, you can publish it, we will go for the publication. Otherwise, if this is not issue, for the secrecy, that is defense related, if someone makes the AK-47, so we are not going to publish those inventions, because everyone start making at home. So it is not encouraged. If it is a defense related, we refer it to the DRDO. So they will give a clearance, means it will go for publication, otherwise it will be a secret. No public can know what is that. So after publication, it will be examined and granted a patent. So formal and technical, so this is already I explained in the before slide. So this is the process actually. So technical examination, it is the examiner will give report to the controller, and he will give all this, whether it is novel or not. So this is the crux, this is the processing. Filing, you have filed application, you will get a application number. And publication, it is early, within 1 month, if it is the form 9 is there, otherwise it will take 1.5 years. So after publication, any person can oppose that. That is a pre-grant opposition. And whether opposition is filed or not, so it is examined and merit if it is grant. And after granting also it will be published, that is post-grant opposition. Any interested party can oppose that. So that is the process. So till that I was explaining what is patent and what are the requirements for application filing and how application will be processed. Now we will be moving on to the second IPR, that is industrial designs. Design means only the features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article. There should be all these designs. It should be applied onto either 2-dimensional or 3-dimensional articles. It can be anything, whether we are cup or anything, shape of a cup or shape of a mobile, shape of this microphone, anything it can be. So it is a 2-dimensional or 3-dimensional, it can be applied on that, or it can be 2D as well as 3D by any industrial process or means. So it can be any type of manual, mechanical, chemical, you can do any designing work. So all these things, but does not include these things. It is the, here in design you will not get any technology. Technology is for the patent, as I was saying, it is for the invention. But design is for only aesthetic look. How it appears. If in the marketplace, if generally there are same product in different shapes, whichever attracts to our eye, we have a tendency to buy that. So this is what it is, like ornaments also. So designing is the creation. So that there is no technology in the designing. It's only a aesthetic look. It is not more advantageous to anyone. So, but it has a appearance it gives. So that is what industrial design. Their technology you cannot get a design, or if it is any trademark you have developed, you will not get it, because they are. So design is for the 10 years and extendable up to another 5 years. That is total 15 years. So Article 2A, any article of manufacture, any substance, artificial or partly natural. It should not be, as I said, no natural things you can get it. But partly natural, partly artificial designs also you can. So there is a natural things, I have modified it to appear a very good look, and it is partly artificial or partly natural. So it can be taken as a design. So original means it should have been first time you are doing. There is no publication of such design. That is the originality. In patent also it is new. We call it as new and novel. Here also there should be a original. They call in the Designs Act. Design means originating from the author of such design and includes the cases. There is no such case earlier. So design of anything, it can be an articles, cycle or mask, anything it can be, any design, it looks a very good for our eyes. So there can be a set of articles also, not only single article, set of like crockery set or dining set. So you can have these sets also as a designs, ornament set. So this, if anything which is having a good looking and attractive appearance, you can take it as a design. So design generally processed at Kolkata office, design office located at Kolkata. Though we receive in all the branches, Chennai, Mumbai, Delhi, we get applications, we take, and it has to be digitized and sent to Kolkata only for the processing. Right now that is the mechanism we have. So because less applications are there compared to patent, so there in one place only we are processing. So that is what the processing. So application fee is for individual small entity and startup it is 1,000, and for others it is 4,000. So all the details as I explained with the form number 1 of patent, so you require to give all the details, and you have to give a sheet of design like this. So this is a prospective view in 2-dimensional and 3-dimensional pictures you have to give on paper, either by hand writing or by painting, whatever they can, to appear that what you want. It is the view you have to give, like teapot, it is that. So you need to make such type of arrangement and you have to submit the either income electronically or physically. So they will give certificate of design like this. So any designs, again it will be published in the patent office journal only, all the designs. It is like this, the publication number and article. So these are the designs. So your IP is protected many times. If you are applied, so you can just you write it as a applied only. Design is applied. You cannot write register. Only when you get a certificate, then only you can write REGD or registered or with the registration number. You can write on the article itself. Many times we have seen that such type of articles. So they are writing on that. Same thing. there will be, if any objections, whether it is a formal or technical, they will communicate. You have to reply within 6 months, and it is extendable by 3 months. And as I said, it is 10 plus 5. Generally, it is granted for 10 years, and 5 years is extendable. In patent, you don't have any extensions. Even a single day, you cannot extend. And within 10 years of completion, you have to ask for that. So the third category is the trademarks. So as concept, it is a trademark is any word, name, symbol or device or any combination thereof. So identifies the goods of that company or service of that company. Day to day we are using several things, including Swiggy, Zomato, so many things we are identifying them with that only, whose service that is. So sir, they have all their names as a word, name, symbol or devices, even including the service marks. They have that. Like Twitter is having a mark, so Facebook is having a mark. So those are all these things, categories, and distinguishes the source of the goods or services from trader or manufacturer. So what it provides, if I take one trademark, what it provides is a monopoly of that goods or service to that company, whichever the company or whichever the person takes. Allows a business entity to build that is the brand building. It is associated with that goodwill. Identifies the source and assures the customers that quality. Whenever we purchase like chappals from Bata, shoes from Bata, so there will be a reputation comes along with that. Oh, it is a manufacturer's that. So that type of things, goodwill, will be created. Like you have different trademarks. Trademarks, including service marks are there, names, collective marks. A society can have collective and they can give it to different persons to use that. So that is a collective mark. Like BIS, Bureau of Indian Standards, they have a certification marks. And you can have a tagline or slogans also registered with that. So shapes, like shapes of a bottle or design of a bottle, that can also be a trademark. And even some sound marks with that sound bite also, you can register as a trademark. So what is required is inherent, distinct one. It should be having a different. It should not be a copy of others. I just we will see that so many copies. We will see it will be a confusing. Especially I have seen with that distillery with the different spellings. Many places I have seen. So those things will be a confusing. That will be a deceptive marks. So if the company wants, they can drag them to the court, or even it is a criminal offense also. It is deceptive marks. In trademarks you have, if you are having a registered trademark, you can go for the criminal prosecution. So like generally, if you are just pending, they will write TM only. If it is, when you are getting a registered certificate, you write with this R. So with the pending, with that registered. So trademarks, sometimes it is a, you can say it is a optional also. See, when I am releasing my products into for a prolonged period, if I am, so public will be knowing that good. Without registration also, you can establish a goodwill and reputation with the customers. So that type of, but only registration will give the right of prosecution in criminal. Otherwise, you have a brand, so you have established a long period, so it will be definitely your brand. So you can also go for the national, regional or international. It is for the 10 years. There is no end for trademarks. So every 10 years you have to renew. If you are, but if you are not using, so you will be losing that right. Even the registered, if you are not using trademark, it will be lost for this. You cannot get that right. So more information you can get in the ipindia.gov.in. So the fourth one, copyrights. So this we are all, some of the other forms we are copying many things and we are violating this right as per the Copyright Act 1957. So this is the bundle of rights and it is an automatic right, no need to register also, you will get it. So if you are literature, drama, all these things you are making, it's a by default in your name, it is published, it is your copyright. Exclusive right given to creators of original work of authorship. So allows the owner to choose the ways these are a copyright. Prevent unauthorized copying. What it gives a copyright is, if I am, for example, publishing my book on any subject, even subject books also. Generally, students, there will be xeroxing many times. Up to 50 it is allowed, but over and above 50 it's not allowed. So it will be a infringement of the copyright of that publisher. Publisher is having that right, or author it is the publisher, so author is having that right. So like novels, all these literature works, all these things, even that CDs or music composer, broadcasting. So all these things, if you are unauthorized copying, so you will be a violator of that. So works is the important. You cannot have a copyright for the idea. Idea you cannot get any IPR. But idea has to be expressed to get some form of the IPR. So what is required to get a copyright is originality, not copied from some other people. So it should be a fixation having, and some creativity is required to have, it is my copyright. Any novel without creativity also you can have your own copyright. But some creativity or means public may like and you will be having a commercial value in that. So here you need to have, there are three parts in this Act 1957. So it is provisions how to register the copyright and how to license and related to rights of the owner of the copyright and its tenure. So futures, provisions, broadcasting rights, they are also copyright only. Even software is also a copyright only in India. No patents for the software or algorithm or program per se. So provisions related to infringement and remedies are there in the Act. So these are the different forms of copyright. You can take literary works, I told novel or books on science or commerce, whatever it is, arts, section 2O, dramatic works, drama, and sound recordings, that is include music works, composition, cinematographic films, and artistic works. So these are all you can take, it's a bundle of right. Copyright is not single right. Like patent, trademark, design, I can simply say this is what you do. So anything, generally personal rights are also there associated with the copyrights. So they can also be owned by this. So who is the owner in the copyright? That is the important. If the literary or dramatic work, whoever is the creator, that is the author of that, is the owner. In music work, it's the music composer, he will be getting the rights. Artistic work other than a photograph, artistic work, it is the artist who created that. And in photograph, picture taken, so person who is taking that photograph, cameraman, will be getting that. A cinematograph, film or sound recording, so in cinema all these things, whoever is the producer, he will be getting the rights of the copyright. And in literary, dramatic, musical or artist which is computer generated, so the person who causes the work to be digitized. So whoever makes the digitization of that literary, dramatic, he might have taken consent and done a digitized work in the either pen drive or in the software or in the website. It is launched, you can download it. So who is the owner for that? It is the creator of the digitized form. So these are the different forms of owners in that. So it has economic rights and moral rights. Moral rights are not transferable, but economic rights you can transfer it to the one to other. So morally rights you cannot, but economic rights you can transfer to a company. So economic rights, reproduction right, distribution rights like cinematographic works or music, all these things they will get a distributive right to creative derivative, right of communication to public, right of public performance, especially in dramatic works, all these things. Right of public performance is important. So right against distortion. What is the moral right? Economic rights you can transfer, but moral, if someone has written some stories, they just slight change and distorted the facts. So against that, copyright person will get it, that right. No one can distort that facts, whatever it is written. And right of his authority or his authorship is recognized. These are moral rights. These are not transferable. Only author or creator can get these rights. So term of protection for copyright is 60 years from the date of publication for cinematographic film and sound recording, 60 years. And broadcast reproduction rights is the 25 years from the, like all these television, all this, whatever they are broadcasting. So 20 years from that broadcast, they will get a rights. And performance, 50 years from the year following which year performance is made. From the next year onwards, you can, if this year performed, so next year onwards it will be counted for 50 years from that. So this is the form number 14 you can use for the copyright. So even though you are not filing also copyright, by creation you can get a right. So there is no question, but you have an enforceable right. You have to prove that it is my own creation. So instead of going that way, if you are registering with the Copyright Office, you can show that. You need not worry about establishing that it's your work. So for literary, dramatic, artistic, musical, 500 rupees, and for to be capable of being used, goods and services, that is 2000, and sound recording, all these there are 2000, and cinematographic 5000. All films which are released, so they will be generally copywriting, and it will be 5000 rupees per application. So this is also similar to that. I'm not just boring you all. I think with the same type application filing, scrutiny. If it is meriting, it will be granted. Otherwise, they will be asked some things to be changed. That is SICLD circuit. That is semiconductor integrated circuits. It's a transistors and other circuitry elements inseparably formed on or inside of a semiconductor insulating material. So layout designs you can have here. It is the layout designs you can get it for the IPR protection. So here is the process. Again similar type of, but this is the what you can get, the chip ICs. Chips you can, whatever you have assembled all this, so they can be registered. So the last one, it is the geographical indication. Here is the right which is not individual right. This is a just difference from the other rights. It is not a individual right. It is a society or firm you have to establish to get this geographical indication right. Even government can get it. So if Karnataka is the leading geographical indication rights in India, one of the leading state who has got several GIs registered. So what is GI? GI is an indication that identifies the product that have a specific geographical origin and possess qualities or a reputation that are due to that origin. So if there is anything which is located in Bangalore, so it has some associated with that characteristics. So those characteristics will be a reputation for that good or that product. So that is the geographical origin. And with that you can, so there are so many GIs registered, like Tirupati Laddu is also registered, Ilkal Sari. So many registered GIs in Karnataka, Chennapatna toys. So they are all registered as a GIs in Darjeeling tea and so many Nilgiri tea. So they are having geographically some importance. So these are some examples. So now I just another 5 minutes I'll take. So we'll have discussions on that. So validity for all, I explained it. What is the validity? Patents for the 20 years from the date of filing. Designs 10 years. You can extend for 5 years. Trademarks, it is n number of period, but every 10 years you have to renew. GI, it is initially for 10 years. Indefinitely you can roll like trademark, but it is subject to renewal. So copyright 60 years for some and 25 years for some. So who can apply? So persons who as creators are assigners of the by creator. So they can, but not for the GI. GI is a not individual or company right. It is only for the government or societies. They have to make and they can get it. So first protect and then publish. This is the points to remember. And all are territorial rights. And only Government of India can have a right to give any IPR. And it is for the limited period except trademark and GIs. No automatic relief when you are not filing. Or you have to take up a case. So many times it happens that I have got a patent, now patent office will protect my rights. Patent office duty is only to grant a right. So it is, you have to enforce in the court of law that right. So renewal of these IPRs to be paid by the applicant or the patentee or the right owner. So patent agent is not compulsory for anything. So there are career opportunities. So we have government jobs like examiners of patents and designs, trademark and GIs and copyrights examiners. We have these. Apart from this, we have in the IP field, if any students are interested, they can write an exam as a patent agent exam. We generally conduct every 2 years. Like this year we are conducting on May 8th next week. So there is a patent agent exam. So if you have that, you can bring any third party inventions to us. Trademark agents, they can, any law holder can register as a trademark, or if you are a degree holder, you can register it as a trademark agent by filing examination, by passing a examination. So, and we have patent facilitation centers and even, so there are women scientist opportunities, like right now we are giving internships in patent office and for many people, so they can also take the benefit of that. And there is a opportunities for lawyers or advocates in the patent litigations or trademark litigations. So for further details, contact. Quickly I can check which for 5 minutes, ma'am? Only 5 minutes. Yeah, so any famous trademark can you identify, students? Okay. Okay. Tata. Horlicks. Lux. So, any other? Babool. What is that?
Bata. Last but one.
Okay.
Cadbury in
These are the things which are there. And first one started with the Pepsi. Pepsi, Amul, Tata, Dettol.
Cadbury.
So you have got, these are all trademarks, at least that much. Which IP can be filed for these? Find the IPs. First, yes, someone said rightly, it is pending. Copyright. Any designs? Can be taken for the design or not? It's a souvenir. You can get a design. And third one, So patent can be all this technology driven. These are all. So trademark also can be taken for this cut apple. So we can take trademark as well as patent on these technologies. So what is this Coca-Cola bottle? Coca-Cola bottle design as well as industrial design also. It can be. So design of the bottle. So even color combinations on the Coca-Cola with the red and this white writing. So they can also be registered. So what is this? It's only trademark. This is the trade name of that company. Which type of IP protects the painting painted by artists? At least you all got it, what I just explained. So what protects the intellectual property created by fashion designers? Designs. Very good. What protects the advanced disc brake for bike developed by the inventors? Designs or patents? Both. Is it a brake? Both. I am not convinced with the design, because is it a brake is for the aesthetic look or attraction? It is to stop the bike. It's a technical work it is doing. Do you think that it is any technical function is there, you will not get a design. So brake will always, it is advanced brake means it's a technology developed, like we have ABS systems. So they are all, it is only a patent, no other you can get it for them. So which of these is a GI?
No.
So BMW is a yes. So this is ironing machine with stem. So patent can be obtained for that. And PlayStation, it's a music. So then worldwide WWE, it's a domain. So what does a trademark protect? An invention, a art of work of art, logos, names and brands, a secret formula. How long? 20 years. If you write an original story, what type of IP gives you the right to decide who can make and sell copies of your work? So imagine a cricketer sets up his own company to sell his own range of cloths. What type of IP can be used to show that the cloths are made by his company? Trademark is right, not the designs. Selling definitely is the trademark. If a company develops a new technology that improves its main product, what type of intellectual property can they use to stop others from copying their invention? Patents. Once again, thank you all. So once again, I thank Dr. Kumar Patil, Director, Registrar Sir, and Team Sir, and entire REVA University for giving me this opportunity, and also honoring the conduction of IP week event by MIC, AICTE, DPIIT, and Patent Office. Very thankful to you all for wonderful listeners as a. So if any questions, you can have a clarification. So I hope I have completed within time. Thank you. Please, sir.
So I have made up a new algorithm that is being there. The new algorithm what I have made, will it be under a copyright or under a patent?
Algorithm, if it is only a program to run the software to run any of these devices, so then it will be per se. If it is the technical effect is only in the algorithm creation, then it is only copyrightable in India. But if you have a technical effect, see, if I have designed a software to run, for example, Android for the mobiles, so the hardware will be, without that it cannot work. So then that hardware and the software you can get a patent. So patent for the
what I just want to know in this particular thing is, in case if you make a software, when with that particular algorithm that is being there, whatever you have made, is in turn with a particular hardware that will be there.
So there is no invention in the hardware.
There is no. It is a software which will be with the
Only program, like apps, like we Google Play Store, we generally download those things. If that is the case, you cannot get a patent for that. If there is a relation of your software developed to run that hardware, then it is a patentable technical effect.
That particular algorithm is required for the particular hardware to work.
So without that, that hardware will not work. So then definitely technical effect is producing in the hardware.
Okay.
So then definitely it is patentable. Along with that, because the technical effect. So there is a two aspects. So software program per se, a program which can be run anywhere, like mobiles also, laptop also, desktop also. So that type of program you may not get a patent. But if to run some device, because it is embedded with that device, a software program for this function, so then it is patentable for that.
So, for example, if I say, like you are making a robot type of a thing, the robot, that particular program will be the one where the robot moves towards you.
Yes.
So, can the robot with the particular...
Yes, it is patentable.
Thank you.
Thank you. Good. Any other? Yeah.
If I develop a drug from
Yes.
a plant next time, can I patent on the plant? Get patent on the plant?
Yes, drugs are patentable. Product patents we are giving, since 2005 we are giving a patent. If you are developing a new drug, so for cancer or even COVID-19, anything, any drug is patentable. You have to establish novelty, inventive steps and industrial applicability.
Plant is extracted, if it is that plant.
Yeah, extracted drug, that is a natural compound. Natural compound, if it is in the same form whatever you are claiming. See, if I take from one plant, I am extracting from that and I am separating and purifying, I am just a structural elucidation I am doing, and if I am wanted that drug to be patentable, so then it is a natural compound, it is a discovery rather than an invention. Only inventions are patentable, not the discoveries. But you can get a formulation of those drugs. For example, if you are making the drug as an anti-cardiac drug, you have extracted, you are using as an anti-cardiac formulation, that formulation is patentable, not drug per se, because the drug per se is already there in the plant. So no natural things are patentable. Same thing, even isolated microorganisms or genes or proteins, you cannot get a patent, but when you make any formulation for usable composition, so you can get a patent for that. Any other questions? Hope you got some what is IPR and how it can be used for protection in India. So, okay. Thank you all. Over to you, ma'am.
Good afternoon to all. Though it's a lunchtime, all of you are sitting very patiently. So thanks again. So thank you, sir. So for taking us through different types of patent, how to apply, what is the term in detail, the entire experience of sirs. He has explained, communicated to us within a short time, and we are really privileged to understand even the career opportunities with respect to patents, and along with that you made the audience satisfied by conducting quiz assessment, so they also felt that they understood the entire session, they were active through the session, Thank you so much. I'm sure that they will use this knowledge and the patent filing they will conduct at their school, and they will further discuss with their school coordinators, their faculty members, and take this knowledge forward. Thank you. Thank you.